In this case, I will be representing the side of the plaintiff, which is Sammy Slugger, who attended a baseball game with his family and 4 children. But he was suddenly struck by a foul ball coming from the field after being distracted by a bag of peanuts coming from a peanut vendor. I believe that my client is right to sue in this case because he was struck by the peanut vendor, which does work for the stadium. Now, to top all that off, I'm going to start with product liability. According to the Introduction to Sport Law textbook on page 35, product liability is liability for harm caused by a consumer product. The product in this case, of course, is the peanuts. And according to page 65, under product liability, me and my client can bring a claim on the company based off of the person who distributed the peanuts as well as the person who's selling them, which in this case is the peanut vendor and the stadium. The peanut vendor is supposed to be selling the peanuts by walking through the aisles and walking down the stands, but he decided to come up with this bright idea to throw them across people and throw them across the stands, and that's when he ended up striking my client. Also, my client can use the idea of negligence to sue in this case. The Introduction to Sports Law textbook also states that negligence is a theory of liability that can be used in all product liability cases, no matter the type of defect. For my client to use negligence, though, in his claim, he must establish either duty, breach, causation, or injury. And my client was injured when he was struck by the bag of peanuts, therefore being distracted and also getting struck by the foul ball. So to sum everything up, due to the negligence of the peanut vendor, my client's vision was impaired. Therefore, his claim is substantial in suing the stadium.